Afternoon, folks. What a day today, huh? Well, smoke 'em if you got 'em. We've got... What's that Blues Clues song? We got a letter, we got a letter. Something like that, right? We got a letter from the governor and the Secretary of Secrecy. Secretary of State. So, we're going to start with opening the Secretary of State's letter first. Because I have a feeling I know what this one is. So, but we're going to go with this one first. This one is from the Secretary of State's office. You can see the letter here. I have a feeling I know what this one is. So, official permit to conceal carry a pistol. Boom, shaka, laka, shaka, boom. That is as official as it gets. So, yeah. Expires in 2023. That's pretty cool. Like I said, I figured I knew what that one was. But the one that I'm really interested that came together, it was from Governor Dennis Daugaard. So, we'll see what this one has to say. And it is personally signed by the governor. Alright, I am writing you. Dear Mr. Abernathy, I am writing you in regards to your recent meeting with my Director of Policy and Operations, Nathan Sanderson, and your subsequent call to my scheduler about the custody of your daughter, Rory. This letter is in response to your request for information in writing. Sanderson has discussed your conversation with me and been in communication with the Attorney General's office as well. Further, I have asked my General Counsel to review the relevant statutes and constitutional provisions concerning the ability of the governor to intervene on your behalf. Based on that research, your case appears to be one for the courts to resolve. As governor, I do not have legal power to intervene. As you may know, the governor does not have the constitutional power over the actions of the South Dakota court system. The judicial branch is separate and independent constitutional branch, Yeah, go ahead. And has sole discretion to determine the jurisdiction and has sole jurisdiction to determine sole discretion to determine the jurisdiction over any particular case. The governor has no ability to compel the courts to take up particular issue, although as governor can request that the South Dakota Supreme Court issue advisory opinion in certain matters. That approach is unfeasible here. In your discussion with Dr. Sanderson, you brought up the emergency powers included in the Uniform Child Custody Jurisdiction Enforcement Act, which the South Dakota Legislature passed in 2015 that was codified in SDCL 26-5B. The emergency jurisdiction over the UCJEA is a power that can only be exercised by the courts. The governor cannot use that provision to intervene in a case such as yours. I know you have done extensive legal research, so you are likely aware that there are various limitations upon the South Dakota court's jurisdiction over child custody cases, especially when the child resides in another state. The full faith and credit clause of the United States Constitution requires that decisions in the court of one state be respected in the courts of another. And this is where, again, Governor, I want to air my grievance with you personally, because, again, you can't respect an order or uphold an order based on fraud. Jurisdiction over child custody cases is also directed by state law. The UCCJEA, enacted by South Dakota and 48 other states, dictates generally exclusive jurisdiction over child custody determinations lies with the child's home state. That home state is generally the state in which the child has continuously resided for the previous 6 months. It is my understanding that your daughter was conceived and born outside the state of South Dakota, that your custody case was heard outside of South Dakota, and that she now resides outside the state of South Dakota. These factors may limit the ability of South Dakota court to take jurisdiction over the case, and it says may, not will or does. So, again, it's still debatable, Governor. But, again, I still want to air my grievance with you in person. These factors are, say, a private attorney, of course, selling the bar, may be able to advise you more on your ability to pursue a particular case before the appropriate court. If you cannot afford an attorney, the State Bar Association may be able to assist you with legal aid services through the Access to Justice program. More information available here. It has also been shared with me that you believe one or more orders related to your daughter in the state of California were issued as a result of fraud upon or by the court of that state. If a court has violated the due process rights of an individual, the proper avenue for challenging such an order resulting from a deprivation of constitutional rights is to appeal the decision through the courts of that state and, if necessary, the United States Supreme Court. Again, you should seek legal counsel to advise you. As governor, it is not within my power to declare the actions of the California court or any state invalid, nor can I direct the courts of South Dakota or any other state to reach a similar conclusion. You have previously indicated that your daughter currently resides in North Carolina and has lived there for some time. A private attorney in that state may be the best position to assist you in your case. Legal information services in North Carolina are available here, or a free helpline at this number. The intervention you have requested is not within the power of the governor of South Dakota to provide. I know you have expended considerable time and energy. I wish you the best with the resolution of your concerns through the appropriate legal channels. Sincerely, Governor Dennis Daugaard, CC'd to Attorney General Marty Jackley. No, it's not over. They keep selling me the bar. Governor, I want to talk to you face to face. I know that that's what your conversation is going to be, and I know that you're going to tell me I need an attorney and this, that, and the other, but like I said, I want to have this conversation with you in person, because I believe it's going to be a lot harder for you to tell me face to face that there is nothing you can do. The reason why I wanted this in writing is so that way that my daughter, when she does sue the states involved in this matter, when she's of age, we'll have everything documented all the way up to the highest offices. And the next step, now that I've exhausted all the remedies of South Dakota, is now I'm going to take and go to North Carolina. So now I have to go through those channels, starting again at the sheriff at the jurisdiction where they reside in the county, then to their state's attorney in that county or district attorney, then to their attorney general, and then to the governor of North Carolina. And once I've exhausted all states, we'll go from there. So, like I said, I wanted it in writing, not for me, but for my daughter. I'm building my case against the states for supporting a fraud order. So, like I said, I still want my face-to-face conversation with the governor of South Dakota. I still want to talk to you in person. I like how you said that our family courts are separate branches, but I still would like to know why they're operating under Admiralty Law jurisdiction. And if you don't believe that they're operating under Admiralty Law jurisdiction, what proof do you have when we have all the rights violations that these courts do? There's still many concerns I want you as the governor of South Dakota to address when I redress that grievance. So, Monday, I will now start what will probably end up being a 2-year long, like this has been, This has been over 2 years for the letter from a governor saying there's nothing he can do. So now here comes the next 2 years in North Carolina, trying to start from the bottom and work my way to the top. Which is, again, why I want to redress my grievance. So Monday I will call the sheriff in the jurisdiction where they reside and file a report. And that's how it's going to go down. So but yeah. It's amazing how many people just, it's not our problem, nothing we can do. It's a violation of your oath of office to support and defend the Constitution. The supremacy clause of the land is the Constitution. You have a constitutional obligation to protect the constitutional rights of your citizens. And if you're not going to do that, then you're not a constitutional governor. And the answer, again, is not get an attorney. This is a kidnapping. By fraud. So, like I said, I'm not a felon. Here's my concealed carry pistol. I'm not a felon. There's nothing that's proven me unfit to be a father to my child. It's a complete violation of due process. So, like I said, this isn't over. This is just one more step of exhausting the limits of the law. So, but anyways, you guys, it's hot as hell out here today. So, I'm going to be waiting for Monday. I'll be making a call to the sheriff's department in North Carolina, in the jurisdiction where they reside. And, start the whole process again in North Carolina. So, South Dakota, I've done everything I can to get the response from the governor in writing. I still want to speak with the governor face to face to redress overall concerns and grievances. And I want him now video documented telling me there's nothing he can do. So, that's how it's going to go. So, otherwise I'm going to burn the flag. Make no mistake about it. So, have a good day or don't. Choice is always yours. We'll see you guys later.